Hello, this is Matt on the Moon Lambo channel, and I have one hell of an update for you. I covered this story yesterday. Here's a new piece from crypto media outlet U today. Judge keeps Ripple in suspense as XRP securities lawsuit continues to loom. Oh, I've got some new information for you, including the document. I'm not a lawyer. What is this freaking document called? Notice of motion. Maybe that's what it's technically called. And so I went through this thing, and this is written up by Ripple's lawyers. And they go on to state that what the plaintiff's challenge, you know, if he had his way, it would eliminate XRP's utility and, quote, destroy XRP markets. So just wait till I get into the specifics of this. I did a little bit of digging. This thing's mostly dry, but I found a number of portions that I think you're going to really want to be aware of. It's interesting stuff here. So this is the strong majority of what I'm going to cover in this video, but good update to follow and after what I already reported on yesterday. But before we go any further, if you would please delicately tap that like button, and if you know deep down in your soul that XRP is not a freaking security, then you're smart, you make sense. You should go ahead and subscribe to the Moon Lambo channel because I agree with you. You're a logical individual, and we should be best friends. So first, I'm going to start with this. I came across this tweet before recording from presumably a member of the XRP community member. This gentleman is named Lamont Richardson, and here's what he wrote. On the Twitters, excuse me, I'm no lawyer, but I did stay at a La Quinta Inn last week, and even I know that XRP is not a security. What is this case really about? Indeed. So let's go ahead and jump in here. A sword of Damocles continues. Yeah, Damocles. I don't know. I meant to look that up. I don't know what the hell that means. Maybe it's something that is just, you know, understood in a different part of the world. But they wrote that. It continues to hang over Ripple, the second most valuable cryptocurrency company. According to a minute order from today's hearing at the U.S. District Court for the Northern District of California, Ripple's motion to dismiss the XRP securities lawsuit has been taken under submission. And that part I did report on yesterday, but there's all sorts of new stuff here. Judge Phyllis J. Hamilton was expected to make her decision on the motion after the scheduled court hearing on January 15th. It is not clear when she is going to announce her ruling. It could take days or even weeks for her to bring more clarity to the table in the long-standing legal battle. On December 4th, You Today reported about Ripple Labs filing a motion to dismiss the lawsuit since it was brought to court after a three-year limitation period. However, Bradley Sostak, the leading plaintiff in the case, doesn't buy Ripple's attempts to throw the case out, claiming that the blockchain juggernaut is still liable for its illegal sales of XRP tokens in spite of the statute of repose argument. And then they go on to have this little section, the subtitle, the little subheading is, Regulators are also on the fence. Heath Tarbert, the chairman of the Commodity Futures Trading Commission, CFTC, didn't specify whether XRP was a security or commodity during his recent interview. And I covered this too, and it's not his place to. You know, he's the CFTC chair. You know, it's... That's not what he's doing here. Anyway, he didn't rule out the third biggest token might fall under the purview of the United States Securities and Exchange Commission, but he also didn't say that it would. Again, it's not up to him to declare that definitively. Anyway, even if the judge does rule to approve the motion filed by Ripple CEO Brad Garlinghouse, XRP's future will still be at the mercy of the SEC. If the U.S. Securities Watchdog cracks down on the token, it will inevitably lead to an immense sell-off. Yeah, there would be some negative implications in the short term, of course. This would just affect the U.S. market as other parts of the world. Certain ones have already declared that XRP is not a security in other specific regions there. Now, let's get to the really fun part. Can we do that? Let's go ahead and jump in now that we're all on the same page here. So again, this is the official court document right here filed yesterday, January 15th of 2020. Notice of motion and motion to dismiss consolidated complaint for violations of federal and California law. Memorandum of points and authorities in support. So there are a couple spots I want to run through for you right around here. Just one moment here. Okay. So here we go. And this is a little subheading here. XRP sales, including plaintiff's alleged purchases. Plaintiff alleges that defendants sell XRP wholesale to larger investors and also sell significant quantities of XRP directly to the general public on cryptocurrency exchanges. Specifically, he alleges that XRP can be purchased or traded on more than 50 third-party virtual currency exchanges worldwide. These exchanges are secondary markets where XRP can be sold not only by defendants, but also by other XRP holders who collectively own billions of XRP. Thousands of whom plaintiffs includes as putative class members who have purchased XRP. The XRP check this out. The global XRP global market is massive, with over $500 billion in trading over the last 2 years. Now, the complaint asserts that defendants sold XRP to the general public, defendant, of course, being Ripple there, before the May 2015 federal government settlement. Complaint and the government's statement of facts for that settlement states that XRP was sold to third parties as early as March 2013 by Ripple and as early as August 2013 by XRP2, which replaced Ripple Labs as a seller of XRP. Now, I've mentioned this in the past, really. You don't know, XRP2 LLC is a registered money services business which sells XRP. They just use a separate entity for that. All right. And here we go. Let me go a little bit lower. Plaintiff's motion to be appointed lead plaintiff in this action asserted a never-ending initial coin offering, ICO, since XRP was generated in 2013. Now, of course, it doesn't meet the definition of an ICO, but there you are right there. So let me jump down here, and here's the most interesting part of all of this. I need to scroll up just a hair here. Sorry, just 1 second. Bear with me. This is a huge document. I want to make sure I jump in at the right spot to share with you the information I intended to share with you. Here we go. Plaintiff's own allegations belie his conclusory assertion of separate offerings. Plaintiff does not and cannot allege that XRP sold in 2013 are any different than the XRP sold today. To the contrary, he alleges that all XRP were created in 2013, or was created in 2013, and that defendants' offerings are indiscriminate. Slow offerings, sales of the same security in one offering over an extended period, are subject to the first offered rule, explaining the effect of the first offered rule on slow offerings. Nor does Ripple's use of escrow, which limits the amount of XRP available to Ripple each month, including for sale, transform the sale of the same XRP over time into separate offerings. Again, so what they're getting at there, obviously, is the fact that this is not some sort of never-ending ICO. There was no ICO. Conceptually, that didn't even exist, and in practice, it also was not the same. Ripple didn't even create XRP. It was gifted to them. So it was already distributed. It was already in circulation by the time Ripple had it, because they were the first recipients of the XRP that they got, right? Anyway, plaintiff's assertion about the effect of escrow is a legal conclusion that need not be accepted as true. Then we go a little bit further now. And I think this is the part where it starts to get very interesting. Notably, there is no inequity in this result, although that is not part of the required analysis. By plaintiff's own allegations, XRP has been available to the public since 2013. Plaintiff acknowledges that since that time, billions of XRP have changed hand among thousands of purchasers on more than 50 virtual currency exchanges worldwide. All right, which are a necessity in the marketplace. There you go. Here, the statute of repose allows the marketplace and defendants to rely on the fact that no claim was brought alleging XRP as a security until well over 3 years after XRP was first publicly offered. Were plaintiff allowed to belatedly challenge. Now, please pay attention to this is the most important part we're getting to right here. Were plaintiff allowed to belatedly challenge the classification of XRP, it would not only threaten to eliminate XRP's utility as a currency, but it would upend and threaten to destroy the established XRP market more broadly. A market involving over $500 billion in trading over the last 2 years, potentially wiping out the value held by the alleged thousands of individual XRP holders around the world. many of whom no doubt disagree with plaintiff's claim that XRP is a security. Yeah, no kidding. I'm one of the holders out there that says, no, the plaintiff is just kind of a jackass. It's just, this is a bogus claim here. It's completely nonsensical. By contrast, when plaintiff bought and sold XRP during a 2-week window in January 2018 at the height of the market, complaint, he had every reason to know that XRP was not registered as a security and had not been sold since 2013 without being subject to federal or state securities laws. Right? And so purchasers were not misled into believing that the federal securities laws governed their purchase. There you go. And so, look, if, XRP is not a security, I don't believe for a moment that it's going to be declared as a security, and that's not even what would happen in this case anyway. That's not what this particular case is necessarily about. They were just saying, so don't think that that's what's on the line here, just to be clear. What the lawyer who wrote this up for Ripple was stating is simply that if the plaintiff had his way and it were viewed as a security, that's what the implications would be. You're talking again about destroying XRP's utility and also just completely eliminating the market out there for XRP. I don't even know that it would necessarily go away because there are other developers building on top of the ledger. I'm not convinced of that. The blockchain would continue to exist, but I think that the short-term price action would be horribly disruptive. It would not be fun to watch. I don't know what exactly would happen here, but I think the implications would be rather negative. But again, I don't believe for a moment it's going to happen, and so I think that it's important that they want to make sure that the judge understands the gravity of the situation and what is actually at stake ultimately here, and also just to kind of get across, and I think they did a fine job. It's a very legal document, obviously. I mean, come on, lawyers wrote it, but just to get the nature of how nonsensical this is through, I think even for somebody me that would prefer, more lay-style sentences because I'm not a lawyer, it's pretty clear what's going on here. I don't think that this individual here has a leg to stand on. I don't think that this is going anywhere. It ultimately, of course, like I said, if XRP were deemed a security, that would pretty much suck. But it's not going to happen, and that would just be one country in the world stating that, the United States, and it's a significant one. Fine, and it's the home country of Ripple, but still. It's just, I can't imagine that would happen. I would be beyond shocked. So I would eat my hat. I mean, I probably wouldn't. I wouldn't eat a hat. That would not be good. But anyway, so this is the thing out of everything that I came across today that probably most caught my attention. And so, I wanted to highlight it, of course, but also to say, none of this is financial advice, to be clear. Of course, I don't have a financial background, but to me, this does not seem like something to worry about just because a Ripple lawyer wrote this up like this. I think, again, like I said, they just want to make sure that the gravity of the situation is known to the judge there. But you can tell me what you think below. I love to hear all sorts of opinions from my fellow XRP community members. I'm not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo!